Hello students, welcome to Legacy IAS Academy. Today we are going to discuss about a controversial law that is also in news, that is regarding the phone tapping issue. So we are going to discuss in this particular video that what is the law that governs the whole issue of phone tapping, and what are the checks and balances that has been put in this particular law to make sure that it is not misused by the police authority. So let us start and delve deeper into this particular topic. But before that, if you look at the context in which we are discussing today's issue, is because on Wednesday, Shiv Sena leader Sanjay Raut actually has claimed that the central government is protecting the IPS officer Rasmi Shukla, who is currently posted with the CRPF. The Shukla is facing an FIR in Mumbai and is also being probed for her alleged involvement in the tapping of phones of Rajya Sabha Member of Parliament Sanjay Raut as well as the NCP leader Eknath Khadse in year 2019, when at that time she was the head of a state intelligence department in Maharashtra. So in this context, let us try to understand that how the phone tapping is done. So to understand the technological aspect of this, now this whole phone tapping process also have changed a lot due to the change and advancement of technology. So in earlier time, when there used to be a fixed line phones everywhere, that time it was done by the mechanical exchanges that would link the circuits together to route the audio signal from the call to whoever wants to listen, to the police authority or intelligence authorities who want to listen about this call. Then later on, when mechanical exchanges also converted into kind of digital exchanges, at that time the same process was done simply by software, simply by logging into computers and operating computer. And as of now, when most of the people as well as individuals as well as even governments are relying heavily on the use of mobile phones, in this time the mobile phones tapping is done by giving a request to the service provider of the mobile phones, service provider of, you can see, SIM cards, and the service providers are then bound by law to record the conversations on the given number and provide these in real time through a connected computer to the concerned authority. So these are the recent times. This is the most common way how the phone tapping is done. Now coming to the important point, that who has the power to tap the phones. So here we will understand that as far as at the state level is concerned, so in the state it is the police of the state. We will talk about which officials or which rank of officials are permitted to that. But generally you can state it is the police of the state that has been given the power to tap the phone. While if you look at the central level, so at central level we have 10 agencies including IB, that is Intelligence Bureau, then we have Central Bureau of Investigation, then we have Enforcement Directorate, then we have DRI, that is Directorate for Revenue Intelligence, we have Central Board of Direct Taxes, Narcotics Control Bureau, National Investigation Agencies, Research and Analysis Wing, then we have Directorate of Signal Intelligence DSI, and last it is the Police Commissioner of Delhi. As police is a domain, we talk in terms of Delhi, the police comes under the domain of central government, not the state government. So Delhi Police Commissioner at the central level is also authorized to tap the phones. Now, what is the law, the main law that governs this whole process? So the phone tapping is governed in India by a law that is made during British era, that is called as the Indian Telegraph Act 1885. And it is in this Indian Telegraph Act of 1885, there is a section called as Section 5, subsection 2, where it says that a phone tapping can be done in the case where we have occurrences of any public emergency or in the interest of public safety. However, this interest of public safety or emergency, how we have to understand that this certain situations are fitted into this category or not. So that has been defined. If the country is facing any threat in the context of the attack on sovereignty and integrity, the security of the state, as well as if there is a possibility of disruption of friendly relation with the foreign states, or there is a possibility of disruption of public order, in that case the phone tapping is allowed. However, an important clause is also mentioned in this particular section, that the authority have to make sure that phone tapping is only done to prevent incitement to the commence of this particular offense. Apart from this, there are also certain exceptions that has been provided in the same section of Telegraph Act, that is with respect to the media or press. And it here clearly mentions that if the press messages that is intended to be published in India of those correspondents who have been accredited to the central government or state government shall not be intercepted or detained unless their transmission has been prohibited specifically under this subsection. So any publication or any communication by the press correspondents cannot be sanctioned, or they should not listen, their phones cannot be tapped on that particular ground. And also another safeguard has been ensured here, that whoever the competent authority that has been recognized by the law who can tap the phone, he cannot do so verbally. He must record the reasons for tapping in writing and then give it to the review committee. That we'll discuss about that later. Now, coming to the point that obviously phone tapping can be done by the state police and different agencies, but who has the power to authorize the phone tapping? So this has been again mentioned in the Rule 419A of the same Indian Telegraph Rules 2007 that has been amended actually in 2007. And what this law says? This law says that at the central level, it must be the Secretary to the Government of India who is the Secretary of Home Affairs. That is, he is the responsible one for the authorization of phone tapping. And if you look at the state level, it is the Home Secretary of the state government. He is the one responsible for authorization of phone tapping. And again, as clear before, as discussed before, again these orders and authorization cannot be done verbally. The order has to be conveyed to the service provider in writing, and only then can the tapping begin. However, we know that many times the police and the intelligence agencies have to deal with the emergency cases where they do not have time to go through all this bureaucratic process of getting the acquired or acquiring the we can say authorization to tap the phone. In that cases, certain cases which are unavoidable in nature, then this exceptions can be done where the rank of even any officer that is not below the rank of Joint Secretaries to the Government of India, authorized by the Union Home Secretary or the State Home Secretary, can also give the authorization. At the same time, many times in remote areas will not have like good means of communications. So in that case, the head or the second senior most officer of the authorized law enforcement agencies at the central level. We discussed 10 central agencies are there. So his head, its head or the second senior most officer of these agencies can also give the authorization. However, at the state level, it has to be ensured that authorization does not come from any officer who is below the rank of IG, that is Inspector General of Police. Then here one safeguard has been inserted, that in the cases of unavoidable circumstances or remote areas, when the authorization is not being done by the Secretary of Home Central Union or the Secretary of Home and the state government, then these officers who is authorizing the tapping, they have to inform the competent authorities within the 3 working days from when the authorization has been done. And then once the submission of application happened to the competent authority, then he had to approve or disapprove it within the 7 working days. If suppose he has not taken any action, he has not communicated whether he has approved or disapproved the this authorization, in that case authorization ceases immediately after the expiry of 7 days. For example, if I give you the example of this 26/11 Mumbai attack, when the terrorists were storming the city of Mumbai, at that time the police and intelligence agency did not have so much time to go through all this bureaucratic process, and that is when the intelligence bureau just sent a direct mail to the service provider so that the phone of the terrorists can be tapped immediately. So in these situations, there has been certain leverages that has been provided to the agencies, both investigative agencies, police agencies, as well as the intelligence agencies. Now, what are the checks that has been provided by the law to ensure that the misuse of phone tapping does not happen either for the personal reasons or for the political reasons? So for that, it has been ensured that whenever interception is being done, it must be ordered only if there is no other way of getting the information. In this law, they have specifically mentioned that first of all, the intelligence agencies, police agencies have to ensure that they have lost all other ways by which they can acquire the information. The only way or the only possible way by which they can acquire the relevant information is just by doing the tapping of the phone. In that case, only interception will be allowed. The second check is that interception cannot go on for an indefinite period of time. Once after authorization has been received, the interception can be done for the period of 60 days, and after that it ceases to effect. If more renewal is required, then it can be extended maximum up to 108 days. After that, the authorization for phone tapping will have to necessarily revoke. Then the third check has been mentioned, that any order that is issued by the competent authority has to contain a specific reason, detailed reason in writing, that what was the reason or what was the rationale behind this step of phone tapping, and the copy is to be forwarded to a review committee within the 7 working days of the authorization. So these are the 3 main checks that has been inserted to ensure that misuse does not happen. Now this process, that review committee, now what is the review committee? So let us talk about this review committee. So review committee again is mentioned at 2 levels. First, at the central government level, when the phone tapping has been authorized by the central agencies, then they have to send the record or the whole communication to the review committee of the central government, and this review committee consists of cabinet secretary at its head and law secretary as well as telecom secretary at the member. So it is a 3-member committee. While at the state government, again the review committee is composed of chief secretary of the state as the head and law and home secretaries as the member. Apart from that, there are some other provisions that has been inserted. First of all, the review committee itself cannot proceed or cannot we can say meet randomly or anytime they want. They have to meet at least once in a 2 month to review all the interception requests that has come under their knowledge. Then they can also may set aside the directions and orders for destruction of the copies of the intercepted messages or the class of messages in this committee meetings, and any records pertaining to the tapping of phones or to such directions shall be destroyed after every 6 months of interval. Now the process we have understood about the phone tapping. So the question comes in mind, is the process of phone tapping transparent or not? So for ensuring the transparency of this whole process, there has been a clear-cut directions for interceptions are to be specified, and also the name and designation of the officer or the authority to which the intercepted calls is being sent to, or the intercepted messages are being sent to, has to be clearly mentioned. Not only that, the officer then have to maintain a complete record with the details of the intercepted call, that which calls were intercepted and how much was the call duration, what was the matter or what was the theme or messages that were exchanged during this call interception and this conversation. All the details have to be completely mentioned and clarified. Then third, as far as the telecom service providers are concerned, there also some internal checks have to maintain, and for that the government has ensured that adequate and effective internal checks have to put in place by the telecom service provider so that unauthorized interception of messages does not occur. So these are the 3 major ways how the government ensures or the law tries to ensure the transparency of the whole process. So that is all about this particular issue of tapping of the phones and the related provisions regarding this. I hope you understood about this topic well. Thank you very much.